Good evening. My name is Rebecca Frick. I'm the president of the League of Women Voters of Amherst. As you know, the League of Women Voters has been working for more than 90 years on voter suppression, and so I don't think I have to tell you how important tonight's talk is to all of us. Bill Newman's distinguished career as a civil rights lawyer makes him extremely well qualified to address our present-day assaults on democracy. Among his successes, he and his co-counsel won the first lesbian custody case at the Supreme Judicial Court of Massachusetts in 1980, achieved acquittals in the seditious conspiracy trial of the Ohio 7 in 1988, succeeded in having the death sentence of a young man on Georgia's death row overturned in 1994, prevailed in the precedent-setting high school student free speech case at the Supreme Judicial Court in 1996, and achieved the release of his Guantanamo detainee client in 2006. He has worked in voter protection efforts for presidential elections in Florida in 2008 and in New Hampshire 2004, and in many statewide office elections. Recently, he was involved in attempts with the Department of Justice to remedy alleged voter irregularities in Springfield. Mr. Newman is also known locally as host of WHMP's The Bill Newman Show. At this time, I would like to welcome Mr. Bill Newman.
So this is a little bit like addressing an ACLU event where before you ever start you have 6 different opinions. And I did have a quick conversation with Chris Pyle, whose sons were in fact the plaintiffs along with Chris in that student free speech case, to try out my theory that I want to propose with you tonight, and he promptly disagreed with me. But that will wait till the end. I like having to commit to a speech such as this because it requires me actually to commit to the ideas that otherwise percolate, but we don't necessarily have to buy into. And I've had this poster for many years. It was given to me by Sid Kaplan, who was one of the founders of the Afro-Am department at UMass. And when we founded the ACLU office, refounded the ACLU office for Western Massachusetts some years ago, Sid was on our advisory board, and he gave me this as a present. It says, Prize Essay Contest. On the subject of the right to vote, an American ideal. Length of essay, not over 2,000 words. Eligibility, all juniors and seniors in the public high schools of Hampshire County. First prize, $25. Second prize, $15. Third prize, $10. Closing date, April 1st, 1960. For further information or instructions, see your English, history, or social studies teacher. And I look at this, I probably should not go too much information here, but I look at this every morning for some minutes. And I was looking at it this morning and I said, you know, it's a good thing that the statute of limitations has run on defrauding high school students, because the right to vote, an American ideal, is fundamentally wrong. The right to vote as an American ideal, by the way, we could make copies of this if anyone wants to get in on this. The right to vote is not an American ideal, or at least not an American ideal that had of long standing. We venerate, or we say we venerate, the concept of democracy. Democracy, of course, being embodied by the notion of representatives who carry out the public will through voting. But the founding fathers did not believe in democracy. What they believed in was a highly unrepresentative, quote, representative democracy, where they were chosen by men who were white and owned property and were not Catholic or Jewish or Quaker or Native Americans, who were over 21 at a time when the population of the country, more than half of the population of the country, was under 16, and almost 20% of the country were African Americans, who of course were disenfranchised. Some say 4%, some say a fraction of 1%. But in any event, a tiny fraction no more than 4, and probably considerably less than 1% of the country voted for George Washington. Now, since 1789, and for the better part of the next 175 years, America increasingly allowed participation in the democratic process, that is, in elections. And in order to understand the sea change that the policy of voter suppression has made in the American electoral system over the past 2, 3, and 4 years, I think it's worth looking at the history of voting and to review the importance of the expansion of the right to vote in the United States. And I think at the end of this talk, I'd like to consider what it means that the greatest voter suppression is self-imposed by the half of the American electorate who will not vote. Okay, we start with rich white men in voting for indirect representation by other rich white men to select the president and the Senate. That changed over time. In 1870, the 15th Amendment, one of the 3 post-Civil War amendments, Civil War amendments, was ratified. The 15th Amendment guaranteed, at least in theory, the right to vote regardless of race, color, or previous condition of servitude. In 1913, the 17th Amendment was ratified. The 17th Amendment provides for the direct election of senators. Prior to that, of course, the senators were selected, literally, by state legislators, who, by the way, were themselves selected by a minority of voters. In 1920, the 19th Amendment gave women the right to vote. In 1961, the 23rd Amendment, which passed, giving the District of Columbia not representation in Congress, but in effect 3 electoral votes. In 1964, the 24th Amendment was passed. The 24th Amendment abolishes the poll tax in federal elections. It was not abolished in state elections until the Supreme Court said so some 2 years later through the application of the 14th Amendment's Equal Protection Clause. And then in 1971, the 26th Amendment was passed, or was ratified, which guarantees all citizens 18 and older the right to vote. Look at this math. It's really quite interesting. We have 27 constitutional amendments and a faulty microphone. But the number, and I'm going to leave this aside. If you can't hear me, just let me know, okay? The first 10 amendments were part of the deal that made the Constitution subject to ratification. We get a Constitution, you libertarian types get the guarantees of limitations on federal power, the Bill of Rights, the first 10 amendments. The 11th Amendment was really a tweak on federalism having to do with primarily lawsuits between the states. And it was passed and ratified in 1795, I believe. So we now have 27 amendments, but let's say operatively we really have 16 since 1795. Okay? Now, 2 of those amendments come up with a zero-sum game. We have the 18th Amendment, which instituted prohibition, and the 21st Amendment, which repealed prohibition. So now, let's say we have 14 operative post-1795 amendments. Of those 14 amendments, 12 focus on or relate directly to the right to vote, or collaterally, how votes are utilized in the electoral system. So, you have the 12th Amendment, which deals with the Electoral College, and the 14th, which is the guarantee of equal protection, which is important to voting and to a number of other issues as well. The 15th, granting voting rights to former slaves. The 17th, the direct election of senators. And that, I think, is important because it was, in fact, a radical change from the theory of the founders who most assuredly did not want direct election of senators. And in fact, James Wilson was one of the founders from Pennsylvania, argued for the direct election of senators at the Constitutional Convention and received for affirmation of his position exactly no votes. Not one supporting delegate to the Constitutional Convention. The 19th Amendment, women's right to vote, the 22nd, the limitation on presidential terms, 23rd, electoral votes for the District of Columbia, the 24th, elimination of poll taxes, the 26th, 18-year-olds having the right to vote, and 5 others, 3 dealing with the effects of voting, the 20th Amendment, 1938, changed the date when the president and the vice president take office, the 25th in 1967 dealing with succession to the presidency in case of removal, death, or resignation of the president, the 27th in 1992 made congressional pay raises subject to an intervening election, and of course we had the amendment that essentially was the Republican response to President Roosevelt winning 4 elections, saying that shall never happen again. Look, those are the overwhelming percentage of amendments to the United States Constitution post-1795. There are only 2 others. One is the progressive income tax, the 16th Amendment, and income tax, and the other was the 13th Amendment, which freed the slaves. And that's the panoply of rights that we enshrine in the Constitution and in the evolution of the Constitution. Income taxes, the freeing of slaves, and voting. Now, when it comes to voting, we also have had legislative enactments to bolster the constitutional amendments and guarantees, including, most significantly, the Voting Rights Act of 1965 and the Help America to Vote Act of 2002. Voting is the underpinning of democracy. And in what we call a republic, and what we conceive of as a free nation, democracy is half the equation. To use a weaving metaphor, in the woof and the warp of freedom, democracy constitutes half the strands. And liberty are the other elements, the other pieces of the fabric of the tapestry. The founders were appropriately fearful of what a powerful government emboldened by a powerful majority or majorities could do. They were, in fact, afraid of democracy. And so, Congress may make no law regarding the establishment of religion, or restricting free speech, or restricting freedom of the press, or the right to petition the government for redress of grievances, the First Amendment. And government should not be allowed to conduct a search or seizure without probable cause, and usually without a warrant, the Fourth Amendment. And no individual shall be twice put in jeopardy or compelled to testify against himself or deprived of life, liberty, or property without due process, the Fifth Amendment. And you shall be permitted and guaranteed a speedy and public trial by an impartial jury, the Sixth Amendment. And you can't be denied excessive bail and detained subject to an unreasonable bail, or be subjected to cruel or unusual punishment, the Eighth Amendment. This list, the Bill of Rights, is the guarantee of liberty, the protection of all of us from the majority, or a government that would impose the will of the majority on minorities, or those who are disfavored, or who are unpowerful. Liberty is the other strands of freedom. As Rachel Maddow put it in the context of marriage equality, we call these things rights. We don't vote on them. They are not subject to majority rule, yes or no. We call them rights because, well, they're rights. Voter suppression, that is, eliminating the participation of potential voters in the electoral system, slices through both the woof and the warp of freedom. It cuts an artery of democracy by creating elections that are literally warped, if not rigged, and thus undermining majoritarian rule and democracy. And voter suppression also unravels individual rights by ostracizing and reducing to second class, at best, citizens who are unpopular and unpowerful, by denying them a critical piece of freedom. Which brings us to tonight's topic, voter suppression in America in 2012, which is purposefully and dangerously at odds with the historic movement towards greater participation in democracy in America. There has been a new series of laws, really a wave of laws regarding voter registration as well as voting itself that has swept the country post the election of Barack Obama. Let's look at some specifics. I'm going to mention Florida a lot because Florida, well, deserves to be mentioned a lot. And it, of course, is this startling example of how a relative handful of votes can decide who is the president. But Florida also gives us a lot of examples because it passed an omnibus kind of voter suppression law that has been mimicked in whole or in part by many other states. So, one of the laws passed in Florida restricted organizations, including that well-known communist group, the League of Women Voters, as well as Rock the Vote and other organizations from conducting voter registration drives. The changes to the law, the restrictions, were so onerous that they in fact shut down voter registration by the League of Women Voters and Rock the Vote and the other groups. The law specifically required the groups to turn in their voter registration forms within 2 days and imposed onerous and enormous fines for failure to do so. The penalties essentially shut down voter registration drives in Florida. Now, what do voter registration drives accomplish? This is a little bit like Coles to Newcastle, discussing this with the League of Women Voters, but I'm going to try. Young voters, first-time voters, older voters, people who have moved because their economic conditions have required them to move, families who have moved. There are entire groups of people who are disadvantaged because they are not enrolled, they are not registered, and without voter registration, they will not vote. Another provision of the Florida election laws would have required this. It's quite staggering. Listen to this. It is a felony to submit a registration form that contains false information, even if the volunteer working for the League of Women Voters or another group does not know and has no reason to believe that any of the information contained in the form is false. Let's try that again. It's a felony. This section of the law, in fact, was blocked by a federal judge because, as the judge put it, requiring a volunteer not only to sign such a statement, but to swear to it, could have no purpose other than to discourage voluntary participation in legitimate, indeed constitutionally protected activities. The registration organizations, the League of Women Voters, sued and they won, blocking that provision, actually blocking both of these provisions. But these are not the only provisions in the Florida law, and some of the other provisions, onerous as they are, remain in effect. Registration is itself a difficult topic, but let me point out a couple of other changes in a few other states regarding registration. The Republican legislature in Maine abolished same-day registration, same day as the election, in 2011, and a referendum revoked that part of the law later in 2011. Only 7 states, New Hampshire, Idaho, Iowa, Minnesota, Montana, Wisconsin, and Wyoming, plus the District of Columbia, allow same-day registration, which leads me to question why other states require such early registration. If 7 states can do it, why can't the rest? Oh, by the way, North Dakota doesn't require registration at all. Just bring your identification, show where you live, and you can vote. Now, it's true, it's North Dakota. They're all going to vote for Republicans anyway, so maybe it doesn't matter. But it really does raise the question why we make registration so difficult. Not all states feel the need to do that. Let's go back to Florida. Another provision of the Florida law ended the long-standing policy of allowing people who had recently moved to update their addresses at the polls on Election Day. And people who are unaware of this may in fact be disenfranchised on Tuesday. Now, Massachusetts election law is actually different. You can vote where you previously were registered for within 6 months of moving. And if you go back to where you had been and are in the right precinct within 6 months. But not every state is as liberal as Massachusetts. Now, why do this? What's the underlying theory? Listen to these quotes. Florida State Senator Mike Bennett, quoted in the Tampa Tribune in May 2011. "I don't have a problem making voting harder. I want people in Florida who want to vote as bad as that person in Africa who walks 200 miles across the desert. This should not be easy. This should be something you do with passion." And another senator, Ellen Bogendorf, was quoted by the same paper as saying, "Democracy should not be a convenience." Let's talk about another piece of the voter suppression puzzle that's gotten a lot of publicity, and that's identification requirements. Now, Florida and other states have passed laws that require a current, valid, state-issued photo identification in order to vote. So, who doesn't have a current, valid, state-issued photo identification? Well, some people don't carry that with them all the time, particularly people who don't drive everywhere. New voters often don't have that kind of identification. Young voters often do not have that kind of identification. Urban voters often do not have that kind of identification. People who don't own cars, never had a driver's license. Older voters whose licenses have expired and have not been renewed. And some people who either do not know and or cannot afford to go to a state registry of motor vehicles or a similar incarnation and pay the fee to get a state photo identification, for which they may have no other need. As of the beginning of 2011, photo identification in order to vote was virtually unheard of. Now, many states did require some form of identification, but it was really as simple as a utility bill to show here's where you live. Now, voter ID laws have been introduced in some 34 state legislatures in the past 2 years. Some of those states have passed laws that have added to the identification requirements, and many have in fact passed these voter identification state ID laws as well. Now, the ostensible purpose of a voter identification law is to prevent voter fraud. But it's voter fraud of a very specific kind. It's voter fraud that, well, for one thing, doesn't exist. But hold on to that problem for just a moment. We're talking about a person showing up at the polls, impersonating another legally registered voter, and casting a fraudulent vote. In one of the depositions taken of a Georgia state legislature, the one who introduced such a bill in Georgia, he was asked, "How many instances do you know of? Tell us all the times it happened. Give us all the information you have about this." To which he swore under oath, actually never heard of his case of this. But it was still critical to him to pass this law. Now, having voter identification does seem on its surface like a kind of mischief that should be prevented. And indeed, in public opinion polls, when asked, do you support this kind of legislation, the polling tends to give the answer, yes. Because in fact, there has been widespread dissemination of misinformation that in fact, this is a problem. Voter fraud encompasses a wide variety of mischief, and sometimes very serious issues. including clerical errors, malfunction of voting machines, mistakes by election officials, votes, wrong lists, mistakes in addresses, and so on, as well as misinformation about election procedures and other problems, including some wholesale corruption of vote counting. But, and you can think of the Nixon-Kennedy vote in Chicago, in particular, in 1960, and raise the issue whether or not Richard Nixon actually was elected president that year, or whether Mayor Daley helped out the Democratic Party. None of that has the least to do with voter impersonation at a polling place, which is what voter identification laws are addressed to. There was a statement put out by the Brennan Center for Justice, New York University School of Law, which looked at all of this in great detail, analyzed all the data, and concluded that a person, this is a quote, has a better chance of being struck by lightning than of being impersonated at the polls. What is a problem with these laws is that they disenfranchise hundreds of thousands of people. I'm going to talk about Pennsylvania in just a minute. But the estimate in Pennsylvania was that this law of a current valid state-issued photo identification would disenfranchise somewhere between 800,000 and 1 million voters on election day. There are very few people hit by lightning, I swear. Let's take a look at Wisconsin while we're on some of these states. Wisconsin passed a similar law, and like Pennsylvania's, it has been enjoined. And let's go back to Pennsylvania for a minute. Again, Pennsylvania has a state-approved law, photo identification, current and state-issued, before one can vote. It was challenged by several civil rights groups, including the ACLU, and in August, the trial judge upheld the law. But the Pennsylvania Supreme Court later ordered the lower court to reevaluate the case in terms of whether or not there had been sufficient notice to make this law valid for the 2012 presidential election. And the lower court, reading the opinion as well as tea leaves, said, aha, no, there has not been sufficient time to give the voters notice of this, and so this law will not be enforced during this presidential election. That said, here's what the state of the law is, or the state of the practice is in Pennsylvania. Next week, this law will not be enforced. If you show up at a Pennsylvania voting booth and polling place and you are duly registered, you do not have to have a state-issued current valid photo identification. But that same court ruling said that the poll workers can still ask people for the identification. Now, they won't be denied the right to vote if they don't have one. But look, if you're standing online and it says down, hey, they're asking for your state photo ID, you're asking for your driver's license, you think people still are going to walk away from the polls and not vote? I do. Now, engendering voter confusion and intimidation is hardly limited to gratuitous requests for photo identification. Consider the use of billboards that declare that voter fraud, large billboards, voter fraud is a crime for which the perpetrator can get 3.5 years in prison and a $10,000 fine, paid for by anonymous groups appearing promiscuously in black neighborhoods in cities such as Cleveland, Ohio, and Milwaukee. Recently, these billboards have a purpose. Their purpose is to intimidate would-be voters and to scare them into thinking that certain kinds of voter identification is required when it is not. Now, there are some variations on this thing. Take Virginia. Virginia law allows a utility bill with the name and address of the voter to serve as identification, as it has throughout most of the 20th and 21st century in most states. Now, what's changed in Virginia is that the voter who does not have a kind of picture ID can no longer cast what will be a valid, albeit perhaps challenged ballot that will be counted on election day. Rather, these voters will now only be allowed to cast what are called provisional ballots. A provisional ballot ends up in its own envelope, off on the side, and it probably never gets counted. A challenge ballot, by the way, is marked as challenged, but it is in fact counted on the day of the election. Provisional ballots effectively disenfranchise voters. Let's look at some of the other recent requirements among the states, including voter identification requirements for proof of citizenship. You can imagine how that kind of a requirement can affect the desire of persons who are recent citizens and or have relationships with persons who may be undocumented from being persuaded to not go to the polls and to not vote. And by the way, the estimates are that many citizens do not actually have the citizenship papers that they would need to comply with these state laws. They're not readily available. Prove you're a citizen, well, I don't have the papers. Let's talk about something else that's of great significance that's ongoing today, and that is early voting. In 2008, the percentage of so-called early voting, that is voting that occurs before Election Day, was approximately 30%. Early voting is believed, and the Democrats believe this, and the Republicans believe this, favors Democrats. Because early voting allows people who don't have access or easy access to transportation, or who can't afford to take the day off from work, who can't stand in line for 2 or 3 hours on Election Day and miss work, to go and vote. Data indicates that early voting is utilized significantly by African Americans and other minorities, and utilized in higher percentages than white voters utilize early voting. Well, I must say, when I was in Florida during the 2008 election, I was in Boca, and there was overwhelmingly white voters in those precincts. A recent study says that new limitations on voting in Ohio would disproportionately affect black voters, and early voting is administered, and I think this is significant, at the county level. And it's worth noting that certain Republican office holders tried unsuccessfully to limit early voting in predominantly African American counties in Ohio, while expanding it in Republican suburban counties. I think this was in Gail Collins's piece in today's New York Times. Although I wrote this speech before I read her column, in all fairness. Indeed, the chairman of the Republican Party in Franklin County, Ohio, Doug Preisse, if I'm pronouncing that correctly, P-R-E-I-S-S-E, when asked by the Columbus Dispatch about his party's efforts to curb early voting there, said bluntly, quote, "I guess I really actually feel we shouldn't contort the voting process to accommodate the urban voter turnout machine." I think the translation is, it will keep black people from voting. This admission rivals in audacity, I'd suggest, the statement by Pennsylvania House Majority Leader Mike Turzai, who said in June at the Republican State Committee meeting there that one particular agenda item, we're talking not about fortuity, we're not talking about individuals, we're not talking about rogue election officials, we're talking about policy. One particular agenda item of the party had been checked off his to-do list. He said, voter ID, which is going to allow Governor Romney to win the state of Pennsylvania. Done. Well, let's give him credit where credit is due. Most people in this room believe in government transparency, and he was, if nothing, not transparent. Now, the argument that's made against early voting is that in some unspecified way, that voting is more susceptible to election fraud than election day voting, but A, this isn't true, B, there's no evidence to support this contention. Early voting, and I did watch it for 7 days, requires voter to come in person and come to the voting place exactly like they do on election day anywhere else. Interestingly, Where some confusion and difficulty in voting actually does come into play has to do with mail-in voting, but Republicans support mail-in voting because they feel, in general, that they receive more votes from the military, and the military uses mail-in voting significantly. As well, they should be allowed to. Now, in Ohio, we can say gratefully that early voting largely has been reinstated for this election. But I would point out that it doesn't mean that the laws, these voter suppression laws, will not be in effect for the next election. And in fact, the Pennsylvania law is specifically allowed to take place after this election. And it's only been enjoined because there wasn't sufficient notification about its efficacy or its validity for this election. So in Ohio, that law that prohibited early voting in the final days before the election was blocked by a court in August. That ruling was affirmed by the Sixth Circuit Court of Appeals. And there is some question about whether the difference in hours that have been worked out will in fact adversely affect minority voters. But in general, at least for the moment, early voting still exists in that state. Let's talk about one other kind of voter suppression that has happened in many states. And that has to do with the purging of voter rolls. States, all states, have procedures for updating their voter rolls and removing names that shouldn't be there. So far, so good. But voter roll purges throughout the country have gone on that in fact purge all sorts of people who are legitimate and registered voters. And again, those purges predominantly affect people who are poor and are racial minorities, people who have moved, people who have had different addresses. In other words, from, frankly, the Republican point of view, segments of the population that are believed to vote predominantly Democratic. This will be fun for a Massachusetts audience. Let's look at Texas. In Texas, which is controlled by a Republican legislature and a Republican government, officials used information from the Social Security Administration to purge the voter rolls of people who had died. So far, so good. This seems real innocent enough. Until you discover that the list that the state obtained from the Social Security Administration was unreliable, and indeed the Social Security Administration told Texas officials that it shouldn't be relied on to see who actually had died, and Texas, responding to this information that you have invalid, unreliable information, of course, used it anyway. 2 months before the elections, purging some 80,000 people from voter rolls, notifying each supposedly deceased person, many of whom received the letter in the mail and were quite able to open it and read it, saying that they had died and therefore they couldn't vote. Imagine, this is enough to give you a heart attack and actually cause that kind of event. Look, people then called their local voting registrar and said, no, really, I'm quite here. And the stories, the anecdotal stories, is after ending up on the phone for hours and hours and hours, they gave up. Those people will, in fact, not vote. There was an NPR story on All Things Considered about a Texas county tax assessor. His name is Don Sumner's got hundreds of calls from angry people because of exactly this situation. He put his foot down against the state and he checked the list that had been instructed to purge from the rolls, and he figured out there's a good probability that more than half of the people on the list were dead. Now, he went for it and he refused to purge the rolls, and he told state officials that they could do what they wished with their list, but he wasn't going to purge the rolls. And he said this in a way that, since we're going to be on public access television, I won't exactly repeat. Despite this event and despite his refusal, the rest of Texas went ahead and purged their voter rolls with a list that the state already knew was inaccurate. These mistakes will not be corrected by next Tuesday. Let's look at other forms of voter suppression. One is the distribution and the inequitable distribution of election funds. If one district has less money, it has fewer poll workers, fewer voting machines, and longer lines. Longer lines matter. Not everyone has unlimited amounts of time to spend in line on election day to vote. And again, poor and predominantly minority areas are affected more than others. Let's talk about a tactic at the polls. This I would doubt you'll see in Amherst, but it certainly could happen in Massachusetts. This has to do with voting challenges. Every campaign has election workers at the polls. And there are various state laws that set forth in some detail how a challenge to a voter can be made. And in theory, one needs to have some personal knowledge of why a person cannot vote at a given place or why this person is not who he or she says he is, that sort of thing. But what counts for personal knowledge is, in many places and in many states, a matter of discretion with the local warden. And if you can have enough challenges, what you can do is slow down the entire process. So though the lines may not be long, they may in effect be a 2 or 3 hour line due to the way in which the challenge provisions of voter laws in various states are misused. Now, to be sure, it is a crime to misuse those laws, and it is also extremely difficult to try to prove. There are other kinds of dirty tricks that have been known for years, going on for years, including, for example, going to a rural voting place and, well, taking all the parking places. That'll make people have to walk a mile or two, and maybe they can't do that, and maybe they're elderly, or maybe they're infirm, or maybe they have to go to work. And you know what? Parking is not exactly a crime. And to prove that it is used for the purpose of interfering with the right to vote, that's not easy. Some other kinds of dirty tricks. One could jam the phones of organizations that were giving voters a ride to the polls. This happened in 2002 in New Hampshire, in the United States Senate race. This was illegal. It is still illegal. And a high Republican National Committee official was in fact prosecuted for his role and convicted for his role in this endeavor. Nonetheless, I would suggest that is probably the exception and not the rule to this kind of voter suppression. And by the way, of course, one could run, there are all sorts of ways this happens. You can run a voter registration drive and, well, manage to misplace the registration of certain people who may be in a party that you're not as affiliated with as another. Look, there's a final, well, it's not a final, but there's one other one I really want to mention, and that has to do with misinformation. In Arizona recently, in one county, the election department gave the correct date for the election in English, and the incorrect and a later date for the election in Spanish. Similarly, a Republican-run election board in northern Ohio, the Ottawa County Board of Elections, recently sent out instructions to some 2,300 voters with a November 8th, not November 6th date as the election date, and oh, by the way, an incorrect description of the polling location. I want to talk a little bit about what the legal response to voter suppression, these laws, these tactics, these procedures, what the legal response is apt to be. And this is an irony, because how these challenges are viewed legally will depend significantly on which human being is wearing the black robes and what he or she thinks about the world and about politics and about voter participation, and frankly what their politics are. Now, when voter suppression laws or tactics, procedures go before the Supreme Court, one analysis could be this. The states have a perfect right to preserve the integrity of the ballot. The legislative judgment on what will preserve the integrity of the ballot deserves deference. These laws, to some extent, at least, perform that function, which is crucial to democracy, and therefore laws that I have generically, procedures and tactics that I generically called voter suppression laws, are indeed constitutional. Don't panic quite yet. The other analysis would be something like this. The laws do not in any way promote the integrity of the voting process. They only serve to disenfranchise minority group members, the young, the poor, the less sophisticated, and the powerless. And because states are burdening the fundamental right to vote without a compelling state interest to justify that burden, these laws, tactics, procedures, purges are unconstitutional. Do remember this, that under equal protection analysis as it now exists at the Supreme Court, the disparate impact on racial or ethnic minorities does not prove a violation of the Equal Protection Clause, absent proof of specific intent to disadvantage the minority group. So, yes, there may be some judicial relief here, but I would caution you to not count on judicial relief to legislative jerry-rigging of elections any more than the courts will interfere now with the gerrymandering of congressional districts. I'd like to turn, if I might, to what I think an answer to voter suppression is. And it has to do with a Civil Liberties Minute that I just reported. These are these public service announcements I did called the Civil Liberties Minute. Okay, between us in the room here, they're really 90 seconds, because if I say, can I have a minute of your time, you probably say, okay, Bill, but if I ask for 90 seconds, you probably say you're kind of pushing it. So we call it the Civil Liberties Minute. And I said that really when I'm reincarnated, you know, like everyone else, I want to come back, I want to have a lot of love, I want to have a lot of attention, I want to have a meaningful life. In other words, I want to come back and be reincarnated as an undecided voter in Ohio. All votes are not created equal. We say in this room, every vote counts, and certainly I was involved in the election, the override vote in Northampton, which lost initially by 1 vote, and then I represented the group that asked for a recount, and in a tremendous legal success, I managed to turn a 1-vote count loss into an 8-vote loss, but at least it did prove the point that every vote does in fact count. We have had other elections in Western Massachusetts decided by 1 or 2 votes. But in the presidential election, every vote, frankly, does not count. What counts are votes in 7 or 9 swing states. Now, there will be disagreement about this, but I think that the reason that voter suppression gets so much attention and gets so much currency and has such a vast amount of money put into it to affect its nefarious intent is because those few votes matter so very much. Voter suppression of eligible voters pales in significance to something that gets very little attention in the national media, and that is voter suppression that we ourselves allow, that somehow we endorse, that we countenance, that half the people in the United States who are eligible to vote will not vote in this election. We are talking about tens of millions of people. And if those votes could determine the election, as opposed to some hundreds or thousands of people in Ohio and Florida and Iowa and New Hampshire and Arizona, did I say Florida again? That would make a significant difference. I want to make a suggestion, and that has to do with the National Popular Vote Bill, which has passed a number of state legislatures, including Massachusetts. Now, this is an interstate compact, and what it says is that this state, our state, will vote for the presidential candidate who wins the national vote all of our electoral votes will be cast for the candidate who wins the national popular vote at such time as states that control a majority of the electoral votes adopt this law. Now, so far, some 270 votes needed in the Electoral College to win. This national popular vote bill has been enacted in 8 states that have a total of 132 electoral votes, including Massachusetts, Hawaii, Washington, Illinois, New Jersey, Massachusetts, as I mentioned, Vermont, Maryland, and significantly, California. Now, this bill has been introduced in any number of other state legislatures, and it may, in fact, become the law as it gets closer to the 270 votes. It will become a raging topic of debate. It is interesting to me that so far it has not. I'm happy to come back and discuss this. What Chris Pyle was saying to me, imagine what the recount would look like. To which I say, imagine what it is to have a democracy in which when the recount from Florida in the Gore versus Bush election was decided, the Carter Center was asked to go and participate in the recount, and President Carter said, we won't do it. And when asked why, he said, because it doesn't meet the minimum standards for a democratic vote that we use in the Carter Center when we go to third world countries to monitor elections. Here's one last irony of this year's election. The winners will decide the legislators and the judges who are going to decide who will vote in the future. And this is not an overstatement. Some 20 states have various forms of voter suppression laws, and another 20 states have legislation introduced or pending. The expansion of the right to vote was a narrative of American freedom for decades. The turning of the tide against the right to vote is a frightening change in this story. It's a story that most frighteningly is moving forward at an expanding pace. This essay contest got it wrong in the sense that the right to vote has not always been an American ideal, but it was for 175 years an increasing goal and an increasing ideal. And it is up to us in this room to try to make it and keep it so. Thank you very much. Comments or questions, or I'm happy to shed whatever light I can. Mary?
Bill, you touched briefly on the distribution of election funds, and I live in Belchertown and I'm on the Finance Committee, and we had a meeting the other night where our town clerk was requesting funds for additional machines. For those of you who don't know, Belchertown's been a rather rapidly growing small town over the last decade and beyond. So even from the last presidential election, we have a significantly larger population of voters than we have. So we're up to just under 10,000 voters, excuse me. The conservative members of our Finance Committee were objecting to it simply because of the financial obligations. And it occurred to me that this must be happening across the country. So my question is, in terms of the distribution of election funds, are there rules or laws in place that you have to have a certain number of machines for population? And if not, can we get those? Would those laws help?
States run elections, and municipalities and other political entities within the states run elections. So I don't think that the federal government actually could necessarily impose a governing standard for local elections. And there is great disparity among types of machines, the accuracy of the machines, the number of machines, the age of the machines, and in fact, the technology of the machines. It seems to me that in 2012, the notion that the United States cannot figure out a machine that counts votes and has a actual record, a paper ballot that gets stored so we can look at them if we ever had to. The idea that we can't do that is absurd. So the answer is yes, it can be done, and there are a variety of reasons, some of them financial, as to this burden resting with local authorities often as to why it's not done. Yes, sir.
It's kind of an off-the-wall question, but back to
okay,
democracy.
It's kind of an off-the-wall
democracy is a Greek. You took that from the Greeks, and my understanding is that there was really one vote in the Greek history that really made democracy work for the Greeks, and that was when they voted about what to do with resources, and that made them a great empire. Right now, we have no rights to vote over the resources. They've been given away or taken by people or been given away because they own some piece of land that was never really given to them for those resources. And so we have no say over what happens to our resources. And so, given, when you mentioned democracy, so you look at the roots of our democracy, what we actually voted on was much more important than what any of us get to vote on right now. And then the other question, I guess there's one question for you, is do you really think that, we should be able to vote on, like, what's done with the oil that's sitting in Texas, and what's done with, the water we own anyways, in theory?
That's not the question.
Look, we live in a representative democracy. We vote for the people who will vote on the issues. And we occasionally have more direct democracy, and we will have some in Massachusetts on our ballot on Tuesday. We will have a death with dignity issue before the voters. We will have a medical marijuana issue before the voters. We will have, this is a little bit complex, but a right to repair question on the ballot here in Massachusetts that has to do with whether or not the automobile manufacturers have to give the information to allow other repair shops the ability to fix your car.
No, I'm sorry.
Some of these are, in fact, leaving that aside for a moment, because the legislature, by the way, has passed a right to repair bill, which makes the ballot question less significant. But death with dignity is a really important issue. Medical marijuana is a really important issue. And we will have direct participation. And these are voter-initiated petition drives that put these questions on the ballot, so that when our elected legislators refuse, for a variety of political and sometimes other reasons, to take up issues, we still have the ability to engage in direct democracy, particularly in states like Massachusetts, where we can have citizen-initiated ballot questions that are binding on the state. Yes, sir.
Is it true that in different states, convicted felons, once they've served their time, do or do not get the right to vote? And why is it varied by state to state? I mean, it seems like it ought to be a federal thing.
Felony disenfranchisement is a very serious issue. In Massachusetts, the law is that once a person is released from a penal institution, he or she can vote. That is not the case in many states where, in fact, as a punishment, as a continued punishment, we say persons with felony records, either forever or for a decade or 20 years, cannot vote. Why? It's a really quite interesting question. Why would we say people, we want you to be reintegrated in society, we want you to participate in your community, we want you to be a productive and law-abiding citizen, and so therefore what we will do is say to you, don't participate in the most fundamental aspect of citizenry. Don't vote. As a matter of fact, we'll never let you. You know what? It makes no sense. It is a matter of simply keeping people as second-class citizens. And I'll make this generalization, if I might. If those individuals were overwhelmingly white, they'd have the right to vote.
Amen.
Yes, ma'am.
I'd be interested to hear.
Okay, and it's by state. It's state by state. Because again, states determine voter eligibility.
I'm interested to hear how you would attack the problem of voter disinterest and voter apathy and the 50% that don't vote. How can we turn that around?
I think that people who don't vote, by and large, feel their vote doesn't matter or doesn't count. If you turned all of those individuals into the equivalent of undecided voters in Ohio, you could engage them, because there will be hundreds of millions, if not billions of dollars spent to identify each and every one of them and to talk to each and every one of them. Make those people relevant to the process, and I think you would have an enormously increased voter turnout. Now, in some countries, more authoritarian perhaps than the United States, there are in fact penal sanctions for not voting. I actually think that's unconstitutional, because I think you probably have a constitutional right to express yourself by not voting or refusing to vote. That said, I think that people don't vote because people are disengaged in a process that they don't think affects them in any way. I was astounded some years ago, not so many years ago, but I was down at one of the local Springfield colleges, and I was talking to a class, and I said, how many of you are registered here in Massachusetts? A couple hands went up. I said, well, that's okay. And I said, how many of you have already voted absentee ballot in the state from which you come? And another couple hands went up. 70% of that class was not going to vote. And I said, wait a second. I'm old. I don't understand a lot of stuff about what you all do anymore. I grant you all that. But how can you not care about what happens to your Pell Grants? How can you not care about what percentage of the loans you have to go to the school? How can you not care? And I never did receive the answer that I felt was satisfactory. And they probably weren't all that happy that I was yelling at them. And it probably was not the best educational moment in my life. But really, it's outrageous. But they don't sort of grasp the connection between their vote and their own self-interest, if nothing else. All those people who are paying less than 15% in taxes because they're only being taxed at the rate for dividends and interest or for capital gains, trust me, they understand the direct connection between their vote and their self-interest.
Oh, yeah.
Yes, ma'am.
So, thank you very much. I would just like to hear what you think we should do here in this room in Amherst, where hopefully there isn't a long list of voter suppression happening. What should we do?
I think that is the question, and I think it's a really difficult question, because this is preaching to the choir.
Yes.
I mean, literally. That said, there are many people who, from this area, are in Pennsylvania, in Ohio, in Iowa, in Florida. And those efforts matter. What campaigns are calling the ground game will determine whether Barack Obama or Mitt Romney is the next president. I think participating in a national way is important. I think that financial contributions, frankly, are important. Whatever you think about campaign finance, at the moment, the money matters. I think that our talking to the state legislators and trying to embolden them to speak to other state legislatures about this national compact, interstate compact on the Electoral College matters. If there were an easy answer or a magic answer, we could have skipped tonight.
No magic answers, but how about taking a look at the national high school curriculum for civics education? It's almost non-existent. I'm not saying that's a panacea, but certainly education, when we get them in the college classrooms, there's that apathy because they don't know. They haven't learned. No one has led them, if you will, to the issues of government and how it works and so on.
People die for this right to vote. We have fought wars for this right to vote. And then our soldiers come home, many of them maimed, and that democratic ideal that we did in fact, and many in fact, fought, died, or became disabled to protect, somehow vanishes. I find it staggering. I find it staggering.
There's no more pertinent question.
I work at a university and have the privilege of engaging a lot of students or student age people. And what's on a lot of people's minds is the fact that some of these significant issues aren't being discussed by candidates of the two major parties, however you feel about both of them. Climate change, the two-party system itself, electoral reform, these aren't money. These are not campaign topics. Neither candidate has mentioned poverty and helping the poor as much as they have defending the rights of the middle class, of which I'm a member. Having said that, I vote, and I know who I'm going to vote for. But I think what is mistaken for apathy in a lot of cases isn't apathy, not the sense that their vote doesn't count, but the sense that it doesn't matter who they vote for. And I think that efforts to kind of broaden the election, to kind of ensure whatever one feels about them, that the Jill Steins and the other third-party candidates get enfranchised to participate and have their views, which used to be, you know, one of the League of Women Voters before the corporation who runs the debates took it over, the chance to expose these views. And I think the way to somehow re-engage the people is not necessarily to assume that they think their vote doesn't count, but to make them feel that their vote counts for the issues that they care about, or that are important.
I agree with that. I think there raises, what you say raises a number of issues. Let me just respond to. First, the Presidential Commission on Presidential Debates is a rigged game. The commission has as its operative rule that a candidate must poll at 15% in the national polls before he or she will be invited to the presidential debates. This is, I think, designed to ensure that third-party candidates do not get to participate, because it's really difficult to get to the 15% when all the polls that have been going on show that no third-party candidate has any significant following. That said, if people could see Jill Stein, she'd get a lot of votes. If people could hear Gary Johnson, who was running on the Libertarian Party candidate, he was a candidate for the Republican nomination and received almost no votes in New Hampshire, he would get a lot of votes. Governor Gary Johnson is a serious person. Jill Stein is a serious person. The other two candidates who participated in the debate of the four lesser parties, it was broadcast, I think, over the internet and nowhere else. These are serious people with serious ideas. The symbiotic relationship between the networks, the media, and the two major parties, I think, is an enormous disservice to democracy. If students at the university said, you know what, there is a candidate running who is actually adamantly opposed to wars. There is a candidate running who actually has as a primary focus the development of green technology and a green United States that in fact can participate in a world economy that is sustainable 20 years from now, which is the world your kids will be living in. I think that would be of enormous interest to students. But the fact is, everyone has busy lives, including students, and when the news is so telescoped in such myopic ways, I think that students are disserved. I think that people who are disengaged remain disengaged, and it is a vicious cycle. Nonetheless, I think that we have a lot of skill sets in this room, and I think we can try to break that cycle.
So I think we could go on for much longer. I would like to thank Bill for
This is one of these stress interviews, right?
I was trying.
You're not nearly as nice as you look. Right?
It's making too much noise. So at the beginning, I liked what you said about taking these engagements on as a way to organize your thoughts, and I thank you for organizing them. It's something that we need to hear, and now we all need to leave and go do something on this topic.
Okay, you've been a great audience. I really appreciated the questions. I really appreciated the conversation.